Hello everyone and welcome to the Consilio webinar. Today's topic, we have the new UK Civil Procedures Rules. And with that, let's get started. Our first speaker today is Gary Bernstein. And with that, Gary, the audience is yours.
Thanks for the introduction, Matt. I'm absolutely delighted to welcome everyone to this Consilio webinar on the new UK Civil Procedure Rules and their impact on e-disclosure practice. Just before I got online, I had a quick peek at the attendee list earlier today and was really pleased to see so many UK and UK-based delegates from law firms and major corporations. So our agenda today is made up of a starter, a main course and a dessert. And for our starter, we'll overview the rule changes and why they've changed. For our main course, we really do plan to give you a proper taste of the essential practices, methodologies and services needed for effective cost and case management. And this part of the webinar really does go across jurisdictions. This applies to everybody that's online. And finally, for the dessert, we'll do our very best to answer all the questions you've been raising as we go through the webinar. If you've got a question now, don't delay, just send it in. So we've got quite a few things to cover today. Here's the agenda in detail, and I can promise you we're in for a real treat. And to help guide us through the rule changes and all the e-disclosure best practices, we're honoured and absolutely thrilled to have two preeminent international thought leaders and practitioners join our panel. Firstly, we've got Marla Bergman. Marla is Vice President, Associate General Counsel at Goldman Sachs, where she leads the firm's global e-discovery efforts and other case-related work. Marla practiced law at Jones Day for 22 years and specialised in the e-discovery phase of litigation. Welcome, Marla.
Thank you.
It's great to have you aboard.
Thanks so much.
Our other panellist is Chris Dale, and Chris was a litigation partner, litigation software developer, and litigation support consultant before he established the internationally renowned eDisclosure Information Project. Chris now writes an authoritative website and blog on the subject and is a well-known speaker in e-disclosure around the world. Welcome to you too, Chris.
Thanks, Gary.
Good to have you on board too. So let's get started, and from that agenda, what we're going to do is the new rules have been in operation for the last few weeks. Now there was some confusion as the rules were actually rolled out here in the UK. So Chris, can you talk us through the new rules, what's changed and why?
I'll do that, and I'll try and do it in the 10 minutes that we've allowed for it. Much of it's encapsulated in two small-looking changes to the overriding objective, which you can see on the screen there. The bold bits, the words "at proportionate cost" have been expressly inserted into the overriding objective, and a reminder, again expressly in there, about enforcing compliance with rules, practice directions and orders, both of which you'd think it would be unnecessary to add, but they set the tone for the changes. Sir Rupert Jackson, to whom we owe the guiding spirit behind all this, had various, as it were, policy things in mind in setting the tone. Costs were to be contained, that was clearly important, but he was also keen to focus on transparency and predictability, the idea that parties might be more willing to litigate if they could predict what the costs were going to be. We're not talking of justice at any cost. That would be a nice luxury, but no jurisdiction can afford that, and that's the significance of the word proportionality here. Existing duties like cooperation between the parties are emphasized, particularly in relation to e-disclosure. There's a greater emphasis than there was, and there always was an emphasis anyway, on active management by judges as to how cases were to be run. And we now have a new focus on the methods, the scope and the costs of e-disclosure. There's a general perception that the courts are trying to line up their objectives with what clients want. Clients want justice that's affordable, and that's very much what Jackson had in mind. And part of that is the rigorous enforcement that has been expressly referred to. If we move on to the next slide, What has changed? Well, as an overview, more cases than before now require a formal exchange of information. We have what's called a menu option of choices as to how disclosure was to be given in place of the previous default of standard disclosure. The idea there being that judges must actually decide, instead of just ticking a box, what level of disclosure is appropriate for the case. For many cases, the courts are actively managing the costs. We'll distinguish in due course between the formal budgets and general cost control of eDisclosure. And for the first time, perhaps, we're seeing judges required to get involved in the methods of disclosure, how it is going to be done. And all that, coupled with the rigorous enforcement of the rules, should give us a new climate. That's the ambition, anyway. Most of this stuff is things that good lawyers have been doing anyway. What you've got here is not new on the slide. It's things that have been part of the role of the court and of parties since 1999 at least. Things like the express obligation to cooperate, the reference there to making use of technology, which we've had in the rules for some time, and a rule I particularly like, the last one there, that the court may take any other step or make any other order for the purpose of managing the case. And that introduces a concept I'm very keen on. If the court can make any order, you can seek any order. And the burden is very much, as I see it, on the lawyers to ask for what they want within the framework of the rules. The nuts and bolts of disclosure lie in a new rule 31.5, where parties are required to file a report not less than 14 days before the first case management conference, which is pretty early in the case, I have to say. And that requires them to describe what documents exist or which may exist. And I should say there that whatever you may conclude from looking at the Ministry of Justice form, we're not talking about listing every document here. We're talking about the categories or classes of documents which parties think they're going to be putting forward for disclosure. This isn't a contradiction to the idea that the case management conference is what decides the scope of disclosure. What we're doing here is giving the court the information that it needs in order to make that decision. Parties must, in this report, must state broadly where documents are, who's got them, how they're stored, and this is the critical point, D there, estimate the broad range of costs of giving standard disclosure, including the costs of searching and disclosing documents. So whether or not your case is one that involves budgets, the formal budgets that are required elsewhere in the rules, for disclosure there is an obligation to estimate the broad range of costs, and as I say, very early in the proceedings. Lastly, one must state what directions that you think are appropriate from the menu option, which we'll see in a moment. The previous default, as I said, was that an order was made for standard disclosure. That still appears as one of the options available to the judge. You can see it there as E. But the judge is given a range of options that begin with dispensing with disclosure completely. There has in fact always been that power, and much of what's in this rule merely emphasizes things that have been there before. So the judge can say, I think this is a case where no disclosure at all is needed. It might, moving on, order that the parties simply disclose documents on which it relies, whilst asking for from the other party for things that it wants from them. It might be disclosure on an issue-by-issue basis. It might be the presence of default, standard disclosure, and again the sweeper at the end, any other order that the court considers appropriate. Down to the lawyers, again, to ask what they think is right, so the court will make the order that is helpful for the litigation generally. How does this fit with what clients want? Well, clients in general quite like the idea of having their costs and risks assessed for them. that's what they expect of any other project they engage in. There's no reason why litigation should be exempt from that. Certainly there are difficulties in relation to litigation. You don't know how it's going to turn out. You don't know what issues might arise or what a rogue judge might do. But in general, clients like to know before they embark on the significant expenditure that might arise here, what they're letting themselves in for. And that's why I said earlier that we're seeing an alignment here between what the court wants and what clients want. The court is deciding the scope of disclosure. The court always has, in fact, but the rules emphasize that based on the information given by the parties in the formal report that I've mentioned. The duties of cooperation and transparency, which have always been in the rules, take really active form here. One must, if you like, separate the mechanics of disclosure from on which one can cooperate generally, with fighting about issues and liability and things like that. There's also a further point appearing in the last bullet point there. There's nothing to do with the court, really. If you're good at this, if you can demonstrate that you're on top of it all, that you have a strategy, that you know what your sources are, then against an opponent who is less well informed, you have as it were, a tactical advantage, because the other side may well hear how hot you are on the subject and decide that it can't measure up. And that's an advantage that people overlook, I think. To summarize all that, parties are expected to educate the court. There's a reference in the practice direction of 2010 to the tools and techniques which parties may use to achieve disclosure. And that translates effectively into software and advice and consultancy from third parties for those firms who don't have it for themselves. And there's a judgment to be made there by firms. Do we have the resources in-house? A judgment to be made by companies, indeed. What resources do we have in-house? To what extent do we rely on our lawyers? To what extent do we go out to third parties who do this sort of thing every day and are good at the identification of the right tools and techniques? It's important to emphasize the point I made earlier, that one can separate the mechanics of disclosure from without giving any ground on the issues. Say, let's just talk about what our joint strategy is here for doing this bit of the exercise proportionately. Not least because if parties are able to agree, it is more likely that what they agree will be approved by the court. That's by no means certain, I should say. But if both parties turn up with no idea as to what they want, then the court may well make an order that's disagreeable to both of them, and that there's that benefit in trying to reach an agreement that you hope the court will approve. What it really comes down to is a focus on what really matters. We see that in a judgment of Master Whittaker, Goodale against the Ministry of Justice, where he required parties to focus, in that case, on the custodians who matter. Yes, there's an outer definition of what the disclosure should be, but who really matters was the question that he asked there. On top of that, as a separate exercise, beyond and covering a much wider range of things than disclosure, for some cases, and I won't go into the fairly complex set of exemptions here, for some cases, parties must exchange budgets for the life of the case. It may be for a component of the case, but the default position is for the life of the case. A cost management order will be made in such cases, which the parties can preempt in that case by deciding what their budgets are, and the court will therefore simply record that. But thereafter, the court controls budgets, and this I should stress is in relation to costs recoverable between successful parties from losing parties. There's provision for cost management conferences, so conferences devoted to the subject of controlling costs. And they may be by telephone, for example. And when at the end the court comes to decide what costs are payable by one party to another, they will have regard to the budget. They're not necessarily bound by it. They're not bound by it for this reason, that the budget components themselves may be satisfactory, but if the overall expenditure is disproportionate to the objectives of the case, then the court may well disallow things even if they've been budgeted for. And that's a serious reason for considering proportionality all the way through. There's provision also for cost capping orders. Now, all this seems unfriendly to lawyers who have successfully argued for a long time that litigation is not susceptible to this sort of budgeting. One judge, Mr. Justice Ramsey, said there will be sweaty palms on the part of lawyers who are confronted by this. Another one referred to blood on the floor when parties try to amend their budgets. The main point, I think, is this, that the overriding suggestion from the senior judiciary is that cost management should always be considered. And if we come back to what I said in starting, that is not something that clients on the whole are likely to disagree with or disapprove of, because that is what they expect from everything else that they do.
Thank you very much for that summary, Chris. That was really, really useful. Chris, I understand that Judge Simon Brown ran a pilot of the new rules before they were introduced across the board earlier throughout last year. Did we pick anything up from that exercise? Is there anything of note to share with our listeners today?
Judge Simon Brown is a particularly active judge in this area, takes case management extremely seriously, and describes case management conferences as a business meeting. Yes, it has judicial implications, but it's a business meeting. How can we run this project? And he has been resolutely fierce with parties who have not applied their minds to what's really necessary. So parties may turn up, for example, and say, we need 3 experts here. And Judge Brown will say, why? Why do you need 3? What are they going to achieve? Why can't you do this bit? Is it necessary for us to do this at all? And that approach, I think, has, as it were, infected the overriding approach to budgeting as it's now gone through into the rules. He emphasizes another thing, incidentally, while we're on him, that if you have agreed a budget and it's proportionate, then the successful party can potentially get an order for costs payable within 14 days, as soon as the case is over. Which is one advantage of being in a cost-shifting jurisdiction. And I really must emphasize that these rules derive from the principle in the UK, which isn't the same everywhere, that the losing party pays the costs of the winning party.
Absolutely. Absolutely. So one of the clear points to come out of that, really, so much change going on at the moment, but proportionality, the adoption of that, so it's just proportionate justice, not justice at any cost. Mara, maybe a good time to bring you in. How does the test for proportionality compare and contrast in the US with that in the UK?
Well, I think it'll be interesting to see how these new rules unfold in the UK, because in the federal system in the US, we have the Rule 26F conference where the parties are supposed to have their business meeting and come to some agreements on the scope of discovery before the Rule 16 conference before the judge. So we have had these concepts in our rules, and I see that they are helpful. It is important for the parties to meet and confer and try to come to some agreement that sometimes is workable. But oftentimes the parties are at an impasse because we do not have a cost-shifting jurisdiction here from the defense perspective that I'm usually on. The plaintiffs are not particularly interested in making too many compromises, and it has become quite an iterative process. So that even if you start your meet and confer, you may reach some agreements. You may have to then go before the court, and the court will issue an order, but that is sort of a changing order, so that we see things more in baby steps, I think, in terms of discovery here. We try to say, we'll give you 10 custodians and run 20 search terms, and let's see where we are. But I think that iterative process is possible here because we don't have such judicial control over the budget.
Great. Thank you for that. I try to simplify things as much as possible, and I think the kind of three headline things that come out of the changes here in the UK are proportionality, legal technology is really at the core here. I mean, technology is expected to be central in kind of boosting cost and case management controls in every case, and also cooperation, really where, you know, where the parties can find agreement, they'll get agreement for costs before they get to the CMC. It's, don't want to fall foul of any of those.
That would be a nice trifecta to have all three of those in any given situation. But yeah. I think that we can have one component step up when the others fail. So if you are trying to argue a case of proportionality to the court and you're successful, that's great. But if you are not successful, if you fail to have the cooperation of your opponent, that is exactly where legal technology has to step up to fill the void of cost containment and efficiency.
Excellent. Thank you for that. Just a reminder for our listeners, if you could send your questions now, and we'll do our best to answer as many of those as we can at the end of the webinar. We're now going to go on to our main course, and we're going to look at the basics here that go across jurisdiction in terms of scoping a disclosure exercise, looking at some of the methodologies and technologies that are at your disposal. Where would you use those and in what situation? And then bringing that back in terms of writing that report that needs to go to the court as well with all your estimates and budgets and things in. So let's start there. And Marla, I wonder if you could help us really there. Can you talk us through your approach to scoping a disclosure exercise? What kind of things do you need to understand before you start to consider which tools and technologies can help drive the cost from the process?
Sure. So to begin with, I think it's very important as the client to understand your own organization, to know where the pockets of data are, and to understand how easy or difficult it is to collect and search through that data. So I think that really the onus is on the client to have a keen understanding of where their data is. And I know some years back data maps were really hot, and I'm not sure it's necessary to have some kind of flow chart, but to really understand where the most useful data is and how does it get collected and what can we do in-house to reduce data volume, because if we can do some of that in-house, that will save us, you know, in the long run from producing too much information to our counsel and then to our vendor and then eventually to have it reviewed, because the key is to reduce the number of eyeballs that have to look at each document. Yeah. So I think step one really is the burden on the client to understand that, and then to keep some sort of metrics and information so that I know about how much data an average person has per year.
How much is that, Marla?
Well, I can't tell you because that would be a secret. but I know the answer, and I know if you're talking about various departments here, which individuals might have more Bloomberg messages, and about how many is typical in a month or in a year. I can also figure what is our average dedupe rate across our collections, so that sometimes folks will say, well, you can't come up with a budget in litigation because litigation has too many variables. And that is true, but I can tell you, generally speaking, how much data would be exported for a particular custodian, how much my dedupe rate is, and about what I would expect to come out of the organization.
All right. And in terms of, getting this part of the whole process, how critical is it to get this part, this preservation and collection right? How does that affect the rest of the exercise?
It is the most crucial step, because when you are coming from a position of strength and knowledge, you are able to negotiate. When you come to the table from a position of ignorance and weakness, with any negotiation, not just eDiscovery, you are unable to force compromise. So I think it's important to get a handle on what you propose and what your data set is before you go into whatever first negotiation you have with your opponents. You want to be able to be the first person to speak if necessary, and to be able to show that you have a handle on your data, you're knowledgeable about these issues, and that you can't be pushed around.
Yeah. Yeah. And in terms of the team that's involved in this, who must be involved, and is there anybody that perhaps shouldn't be involved at this stage?
Well, in the initial phases, we have, it depends on the organization, but most organizations will have a technology team, either engineers that are familiar with your retention system, collections folks, whether they're in legal or technology. Usually you'll have some legal assistants, paralegals involved in the process, maybe an eDisclosure or eDiscovery lawyer, and then the actual lawyer on the case. And I think those are the folks that are necessary to kick things off. And one person can fill more than one role.
Yeah. Chris, have you got any advice in terms of key considerations in making a decision to self-collect the data?
Well, before that, can I just sort of illuminate in gold type what Marla's just said about not just what the court requires out of all this, but showing that you're in charge. That lovely line, showing you can't be pushed around, is a significant component. Not a statutory component, it doesn't appear in the rules. It's what I referred to earlier, what I meant earlier when I referred to the strategic advantage that you gain by showing that you're on top of all this, not just what your own material is and what its costs are, but what the prospective methods are for dealing with it. Showing you can't be pushed around is not only significant and helpful, but it's also the sort of thing lawyers like. They rather resent the way rules are containing the old way in which we used to run litigation. And here the rules are handing us an opportunity to show that we're tactically and strategically in command of all this, with a view to rolling over the other side with the rules behind us to tell us it's the right thing to do. Right, that much said, moving on to your question, self-collection is considered anathema in the US, largely because of the many opinions, judicial opinions there have been about failures to collect, which tend to push people towards the idea that it's better to pay somebody to do it professionally and to use the right technology to do it. And self-collection has become something disapproved of in the US. I'd rather look at it a different way. Is it actually going to cost you any more to have it collected by formal means by experts than it's going to cost you if you self-collect? There's no rule, there's no case law that prevents you self-collecting, and in some cases no doubt it is the right thing to do. But I think before people go down that route, they might just like to get an estimate or even better a quotation from somebody skilled in these things. What would it cost to have them do it for you properly? And set that cost not just against the direct costs of doing it yourself, but against the prospective costs of, for example, a failure to pick something up as you went along, of having to go back and do it again, and all the rest of it. So self-collection is not disapproved of in the UK, but in summary, it's worth finding out what it would cost to have it done properly.
Yeah. I'm looking at the slide now, methodologies and technologies, aligning needs, capability, cost, time and effort. And this is kind of moved on kind of the next stage. So we're in a situation where we've got a firm handle on the volume and types of data that's involved in the matter. How do you go about really kind of assessing which technology is going to give you the best result in reducing the volume of documents for review? Is that a different assessment each time, or do you use your favorite tools and methodologies over and over and over again? What's your view there, Marla?
I think you can have buckets. So, we have similar types of cases, and so I can estimate sort of in a bucket this civil litigation, a third-party subpoena, a regulatory inquiry. And certainly one size does not fit all. So in a regulatory inquiry, for example, you may have to put eyes on all the documents and have no culling. You might need to produce all documents of a particular custodian for a period of days. That is a very different technology than a case where it is perhaps an inquiry, a regulatory inquiry, and you're really not sure what happened, and you're really not sure who the right folks are. So you might need some early case assessment technology to help you figure out what is going on and what you're looking for. On the other hand, you might have a civil litigation that is a typical case with many custodians, and you're going to negotiate search terms. And then depending on the volume, is that enough, or do I also need some technology-assisted review, some predictive coding? What is the posture of the case and the cooperation I have with the plaintiff? So these are the factors that I would consider. And each time I like to have a discussion with outside counsel, so together we can come up with a plan for what technology we're going to use, what vendors we're going to use, how are the documents actually going to be reviewed, and we can come up with sort of a map for the review.
Excellent. And that really does sound as though you're preparing that report that could be submitted to the court that we now need to do here in the UK. Because you're filling out all those gaps. That's your kind of your strategy moving forward. That's not following the route of standard disclosure. In terms of early case assessment, what's your experience of ECA and the benefits that it can yield you when you use it?
I am a big fan of ECA. I find it extremely useful in culling down data sets. But there are a few components to making it successful. First of all, you have to get cooperation from your outside counsel to learn the tool and to use it effectively. Because often outside counsel is not familiar with all of the technologies available. They are too practiced in doing a doc-by-doc linear review. They're worried that they're going to miss something, and they don't want to leverage the technology. And so I think it's really important to form a partnership with your eDiscovery service provider and your outside counsel, and to have someone at outside counsel who is invested in this and knowledgeable and not at the most junior level. Right. So I really like to have a mid-level or senior associate who's going to work with the service provider to use the technology to its full advantage.
And in terms of, is there a percentage benefits yielded compared to full processing of data? Have you got some metrics and things around there you could share?
Well, it really depends on the case, but I would say that you can typically reduce your data set by 1/3 if you're using ECA effectively. And that is to look at date ranges, to see who's speaking to who, to figure out custodians that are really not relevant or are particularly relevant, to reduce email addresses that you may never need to review. So if I have a custodian who's a really big shopper on eBay, I can reduce that volume at a click of the button. I can also see, with using concept analytics, What terms are used most frequently together, and how should I hone my keywords to find things that are more particularly relevant? And using it can also then lead to cooperation, because if you've negotiated keywords and you use the ECA function, you may be able to go back to your opponent and say, you know, we've done some investigation and here's what we say. Can we tweak this list?
Yep, yep. That's great. Chris, have you got anything to add about the power and benefits of ECA, particularly in maybe our system?
Well, I quite like to strip out those fancy capital letters, the early case assessment, and look at it instead, perhaps rather more long-windedly, as early assessing the case early. Never mind to begin with how you're going to do it. Does it make sense to assess the strengths and weaknesses of the case and the potential expense of running it? There's no alternative but to answer yes to that question. So the next question is, can you assess the case without assessing the data? Answer, you can't, seriously, given in most cases anyway, given the cost component as well as the evidence, of course, that lies in the data. So the one follows from the other. One then gets into the next stage. What is the most efficient and effective way of doing that? And that very often is using some kind of software of the kind that Marla has talked about. But it's the function that matters, the assessment at an early stage of the strength of your case based on its data that matters more than what particular software you use. Bear in mind that in both our systems here, we're talking of a two-tier approach. The court sits in the middle and is going to make a decision. It can't make that decision, however, until it's had a certain amount of information from the parties. And it's the ECA stage, the early assessment of the case stage, that provides the parties with the information necessary for the court then to decide on the next stage. And if we, as I say, strip out the capital letters and the apparent magic of a particular kind of software and focus instead on the function, I don't think there can be any other answer than we must do this.
And do you think this will play an important part in the new regime here in England and Wales?
I can't see how anybody can properly prepare the report that's required 14 days before a CMC without having done something of this kind. How much has to be done is, like everything else, a matter of proportionality. There are some cases which will not involve a great deal of skill and work. If one does what Marla says and knows enough about, as a client, knows enough about one's own system to be able to provide broad answers very quickly, then there is less to assess on a case-by-case basis. We have, as you probably know, the electronic documents questionnaire, which is ancillary to our practice direction 31B. That's used formally, it's required in a very narrow range of cases, but actually it's extremely valuable to be used in a much wider range of cases where clients might, for example, keep that questionnaire as a sort of standing document, so they always know what they have in relation to particular areas of work. Because the real issue that's going to come here is that lawyers are going to say, my clients don't want to spend a lot of money on getting ready for the case management conference.
Yes.
And nobody wants to spend more money than they have to. If you're, as it were, a repeat litigant, then it seems daft to me not to do exactly what Marla says and keep those statistics so that each early assessment of a case is informed by what's happened before.
Yes, yeah. That's excellent. And Marla, you alluded there about this perhaps is the moment to involve a counsel and the external vendor. Is this the optimal time to bring in your vendor and have a discussion with them, or is the scope to bring them in early or maybe at a later stage? Where's the best time to get them involved?
I think once we know that we're going to really embark on a discovery exercise, it's important to form that partnership. I really think that we need to have this three-prong approach with the client, counsel, and the vendor, and that we need to have collaboration, respect, and communication to successfully conclude any discovery endeavor.
That's great. And you alluded as well a bit earlier about predictive coding and how useful that can be. That's a bit of the buzzword in our industry at the moment. But what's your own experience of that, and how much of a silver bullet is it to the problem of just growing amounts of ESI?
I think that predictive coding is a great technology and can be very useful. The dicey issues are how much cooperation do you need to have with your opponent, and if it's in a regulatory or civil litigation context, you know, the answer to that may be different. And then, you know, if you don't feel you can have the cooperation of your opponent, and there are certain transparency issues to using predictive coding, then how can we use predictive coding without having to disclose it? So how can we just use it to tier our document review, to bubble up the information that is most important, to put the right eyeballs on important and less important information? So I think there are various ways to use the technology depending on your case and the degree of cooperation and transparency that you have.
Yeah, yeah. And I think that what you're saying there as well is, you know, predictive coding as a workflow has got lots of different uses, particularly in quality control as well, maybe at the end of the exercise. So it's not just about, you know, whittling down documents right at the start of the process, but it's got lots of uses at the end too. Because if you, what's your take on?
Well, the most significant thing that you get out of predictive coding, and we haven't got time here to explain what it all amounts to or what the implications are, but one of the outputs is the word that appears on the left-hand side of the slide in front of you, prioritization. The idea that documents are ranked as a result of the first round of input by a presumed order of relevance, presumed stressing the fact that this is draft and that there's plenty to play for in terms of quality checking and reviewing that presumed order. But if you were to say to lawyers, would it be helpful to you to have the data presented to you in an order from the most likely relevant documents down to the least likely? Who's going to answer no to that, if put bluntly? And that particularly in a context where that we have here, where proportionality is going to come down like a guillotine at a certain point across the range of documents, then to have that presumed order of relevance as a place to apply the guillotine. If we apply it here, then it'll cost X. If we apply it there, it'll cost X times 2. That sort of approach is clearly a helpful thing to do. Like everything else, the lawyers will need to understand what these terms mean. What is concept searching? What is clustering? What is predictive coding? Those words that you see in the middle there. What do they cost? What do they do? What do they save? As a broad matter, in the abstract, as it were, not in relation to any particular case, but because there isn't much time, frankly, between the beginning of a case and the filing of this report. Every lawyer who purports to be involved in large-scale disclosure or discovery exercises ought to know what these tools are and do and cost, so that they know which one is likely to be best. We're going to see particularly for cost budgeting cases, we're going to see the court saying, well, if you say we could do it this way, is there another way? So I think we're going to see people going to court with more than one option. We can do it this way and it has these implications and costs, or we could do it that way and it has those implications and costs, which will require knowledge of more than one approach. I think it's important also to move on to the next flag in the slide there, the document review one. There's multiple ways of dealing with review. Solicitors have tended in the past to do it from their own resources, and for some firms that might well be the best, meaning the best at the crossover between quality and cost and time and all those components. But one ought to be aware that there are other ways of doing it, that one can outsource it, that there is a concept called managed document review that brings with it transparency and predictability in a way that relatively few law firms are able to manage prospective reviews, and by manage I mean in part cost. No one is saying that any one, just as with the technology, no one is saying that any one of these approaches is right, let alone is right in all cases, but one ought to know what the implications are of each of them. And in advance of not just the next case management conference, but case management conferences generally.
Marla, managed document reviews are a pretty established industry now in North America. It's been going for some time. What's your own personal experience of that, and can you really get benefit out of using an LPO?
Well, here's what I think. I think that law firms need to work with their clients to do it most efficiently. So the days of having senior associates review hundreds of thousands of documents are finished. And whether that is the truth, whether we're in the U.S. or in the UK. So we need to think in broader terms of who we're going to have do at least first pass review. Whether that's a managed review, whether that's having contract attorneys sitting in a law firm, whether that's having contract attorneys sitting in a service provider space, whether we're paying for technology and review bundled together, or whether we're unbundling it. Those are really just nuances. But the concept of having lower cost folks reviewing documents is something that is critical to think through. And so I think in the U.S., everyone has already accepted the fact that these discussions are going to take place, and the documents are going to be reviewed somewhere other than, you know, by the lawyers in the law firm. And I think in the UK, my experience is this is a slower realization to come, but one that absolutely will.
And something we picked up in our business, that even though you're, you know, in the matter, the documents are being reviewed by a third party, it's still really important for the client to embed themselves in the process, in the document review itself, to get a feel for the issues in the case as the review is going on.
Well, also to emphasize that the lawyers retain responsibility for this.
Yes.
And they can't have that responsibility if they're not wholly on top of it and informed.
Yeah.
That's important because a great many lawyers hear of these things and say, well, I can't do that because I have a duty and a responsibility. Well, again, you can't really say that without identifying how these outsourcing, how these managed review, all these different variants, how they work and to what extent they work with the lawyers to provide the same function as has historically been performed within the law firm, but to do it perhaps more cheaply.
Excellent. Well, I'd like to go on now to just look at the mechanics of producing the disclosure report for the court and kind of really what's going in there, because I understand that you'll have to actually budget or put some estimates in for the costs of a standard disclosure, and then propose the direction for the scope you're really looking for from the menu option that's available. Chris, could you maybe talk us through that?
Yeah, let's park the word budget in a different place, because budget strictly relates to those cases that are under cost management, and we must be absolutely clear that whether or not a case is under cost management, the parties are required to make this estimate of a broad range of costs specifically in relation to disclosure. There's an interesting question that arises as what are the boundaries of disclosure? You have to collect documents a lot for witness statements. You have to collect documents for all sorts of purposes. Are those disclosure? Are those part of disclosure? Well, that's perhaps a budgeting point, but it's not all the costs fall into neat pots, I suppose is what I mean here. we have to wait and see what the courts are actually going to expect in terms of these broad range of costs. But firstly, two things about it. Firstly, anybody who says it's going to be easy is a fool. Secondly, anyone who says it's impossible is equally not focusing on what clients want, never mind what courts want. It ought to be possible to come up with a broad range of costs, particularly if you do what Marla has suggested. If, as a historical matter, you keep as a company the numbers, the metrics, that you can use as part of the tools to estimate the prospective cost. This case is a bit like that case. What did that case cost us? For example, the same custodians tend to come up again and again. The same people are the ones who get involved in the deals that end up as the subject of litigation. One could keep the metrics about them, perhaps even keep the key documents from them. It's important to, in looking at whether this is helpful or not, it's important, I think, to look at what proportionality means. And it means nothing if it doesn't have in it some estimate of what the costs are going to be. And we've used the word a lot since 1999 without perhaps focusing clearly on predicting costs.
Right. Okay. I'm conscious that we're nearly out of time, and there has been quite a few questions coming in from our listeners. Practice priorities in the new regime. I think some of these are quite obvious, but we're seeing now the emergence of partners in law firms who are readily adopting the mantle of eDiscovery and eDisclosure experts. So, when you're going to be sitting at the case management conference, it's worth investing time and effort to get familiar with the process of scoping a disclosure and getting to grips and keeping a note of the key metrics and benchmarks going through. And perhaps, technology is moving still rapidly. There's technologies coming out all the time and evolving. So perhaps that's the role of the vendor in this exercise to keep their clients up to date with new developments and guide them to the right answer there. On the disclosure report, well, that's something the law firms will help with, and again, vendors can perhaps inform the technical aspects of what's going into that report too. So perhaps we could maybe take a couple of questions now that have come in. And Chris, maybe you can handle this one. What's the attitude UK judges have to technology like predictive coding?
Ah, the old chestnut. Everybody asks that one as if there's a sort of standard type judge who's has a standard level of knowledge. That matters more in the US, where parties are much more guided by what another judge said in another case in another state. We're not, frankly, much interested here in what other judges have said. It's a product of the very wide discretion given to judges, that they make up their own mind about cases, so you can't go and find precedents anywhere. We also don't report case management, most case management issues. The burden falls, as I've said a couple of times during this, burden falls very firmly on the lawyers in front of the court to explain why this permutation of technology and techniques is the right one. Judges, bear in mind, have spent their lives as barristers being eloquent and knowledgeable today about something they knew nothing about yesterday. And if the lawyers will take seriously the business of explaining to them what this technology is and what it does, perhaps with the help of the providers of it, whom judges would be perfectly happy to hear from, they will make the right proportionate decision. But we would search in vain for a universal answer to the question, what attitude will judges take to any particular kind of technology?
Great. Marla, perhaps you can help with this question. Why are the developments in the UK relevant in other jurisdictions?
Well, obviously, there is applicability to what goes on in one jurisdiction to another. Courts and judges are always sort of interested to see what's going on in other places, and also it will form the opinion of a multinational client. So, you know, here at Goldman, we have cases all over the world, and so what is going on in the UK will affect the way I do things, even if I have a case in the US. More information is power, and trends seem to roll across the pond, and we see that here where this concept of the early case assessment, of conferencing prior to the court order on disclosure, these are concepts that I think started over here in the U.S. and didn't take too long to get across. So the issues that are being dealt with now in the UK are absolutely instructive to multinational corporations like mine, and also just to the arguments that we make.
It's worth pointing out that there are pending rule changes in the US, one of which is the insertion of an express reference to proportionality in the definition of relevance. So there's mutual exchange of ideas here, I think.
Yeah. Well, our time is just about up now, and thank you very much, Marla and Chris, for your support today. That's fascinating. And I'd like to thank our listeners too. I've no doubt we're just in the early days of rule changes here in the UK, and I'm sure we'll come back to revisit the subject and look at what the impact's been very soon. So thanks very much for listening in, and see you again soon.
Thanks so much.
Thank you.